You're listening to the Subrogation Support Network, a podcast from Matthiesen, Wickert Lehrer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, your host with the Subrogation Support Network podcast, powered by Matthiesen, Wickert Lehrer, subrogation law firm. Today, I am absolutely honored and privileged to have two excellent podcast speakers, attendees, co-hosts today in Patti Rutzinski with Secura Insurance Company and Griffin Gross, attorney here with Matthiesen, Wickert Lehrer law firm. He is usually right upstairs of me. Now he is speaking, coming to you directly from Naples, Florida. How's the weather down there, Griffin?
I think I clocked out at 95 and sunny, so it is gorgeous right now.
95, nice. Beautiful. I mean, Griffin rushed out of the airplane and ran across the hotel just to be here with all of us. So thank you, and Patti, thank you as well. So to begin, let's let you both tell me a little bit about yourself. So Patti, what are you doing over at Secura?
I am a supervisor in the subrogation department. I've been here a super long time. We won't go into those details, but I supervise about 12 people, and we do all lines, P&C and work comp subrogation, and I love it. I love the mix. I love all of the aspects of subrogation.
And Griffin, how long have you been privileged to work with Ashton?
My privilege extends about a year and a half in that regard. I've been an attorney for about 3 years now, coming up in a couple of days. But yeah, I've been with MWL for about half of that time.
Beautiful. And Griffin is excellent to work with, by the way, if you ever get the chance. So let me introduce the topic a little bit. So all three of us are going to be presenting next week at the Workers' Compensation Convention for CLM in Chicago. We'll be going down there and enjoying the conference and speaking on the fascinating topic of work comp subrogation. The purpose of this presentation is really to discuss kind of the 101 aspects of what is workers' compensation subrogation, to get into tips and tricks for investigation and how to investigate your claim, to talk about the different types of laws, premises liability, product liability, auto collision. And then from there to go into the more unique aspects. We talk about choice of law issues, the variance between the states, right? Allocation formulas. How is recovery going to be allocated after a settlement's made? And we expand upon all of that today. This is more of a teaser, a conversation, just to give you an intro to what we're going to be talking about. But anybody, I encourage you, if you're going to be in Chicago for CLM, if you still have time to register for that conference, do it. It's going to be a great conference. Or otherwise, pay attention to the MWL website because we post and do these webinars all the time. So to begin, let's start with Patti. So as a claims manager, I'm assuming that you have some significant on-the-ground experience in handling and supervising these claims. So what's the largest hurdle that you've had in effectively handling work comp subrogation?
Well, actually, Ashton, there's a couple hurdles. One of the big things is that we have work comp claims in various states. So we have to find out the variance. Do we have to send out notices? What is the formula in those states? And I would highly recommend the Work Comp Subrogation book by Gary Wickert. We call it in my office the Work Comp Bible. It goes into great detail as to information we need. So we utilize that quite a bit. Another hurdle we have is that people are busy, really busy. So it is hard to get in touch with the people that you need to find out the status of the scene or to get a contract or that information. So my direct reports might be making many, many phone calls to find out some information to get in touch, especially with a commercial business, to get that information that we need to start that investigation rolling.
And we didn't even pay Patti to give us the plug for the book. It's actually that good. Not only do we have the book, we also have the chart. So go to mwl-law.com. We have the work comp chart, which is frankly, we have thousands of people that view that chart every month.
We use the charts all the time. They're awesome.
Right. And that's not just a plug. We don't get paid for the charts, but the beauty of it is, it helps. These are things that we do as legal counsel, as subrogation counsel, to help our clients and those in the industry to just simplify the process. Because as we'll discuss in a few minutes, a lot of this isn't about being an expert in everything. Nobody legal counsel included, is going to be an expert in the law of every single state when it comes to, be it future credits, allocating claims. Nobody knows everything off the top of their head, but it's about knowing where to find it. And it's about knowing the right people to have on the board in your corral to be able to assist you. So Griffin, one of the major hurdles that I've witnessed is how many carriers delay retaining legal counsel, subrogation counsel specifically, until too late. Either they're relying on the plaintiff's counsels, their promises to protect the lien, hoping to avoid, maybe they can avoid the cost of intervention, or just sometimes they're just templatizing. I think I just made up that word, but let's say templatizing the handling of the claim. So they're just sending a demand or a notice of lien letter every 5 months. What are the pitfalls that you've seen in our practice in carriers waiting for the last minute to retain counsel, or even failing to retain counsel at all in some states?
Yeah, I think you're absolutely right. I think one of the main things that I've noticed is we tend to get a lot of stuff that has like notice issues. So depending on the state, every state has a different notice requirement for the work comp lien. You either have to get plaintiff's counsel and defense counsel on notice of your lien, plus you have to send them statements, plus you have to intervene, plus you have to do X, Y, and Z. And all of a sudden, if you're not retaining subrogation counsel, your lien's just thrown out the window. I mean, you're kind of SOL on the whole lien altogether. The other thing is a lot of the times the investigation into the work comp lien itself and into the actual injury is kind of lackluster without somebody kind of on the ground and digging into it. A lot of the times, as subro counsel, we're retaining our own experts. We're attending inspections, depositions, all of these things to make sure that, we have an active part in, defending our lien. And in some states, it's not as required, but in a lot of states, it really is.
Absolutely. And there's certain states where it's a must, where legitimately the statute says you must intervene, right? There's other states like Wisconsin, for example, where we are automatically made an involuntary plaintiff. So we have to be involved. We have to be engaged. And then there's the majority of states where there's no actual requirement, but plaintiff's attorney has all kinds of routes and means to gerrymander the settlement, to apply it to maybe loss of consortium, to a spousal claim, to apply it to just non-economic damages, pain and suffering, where there's all these ways for plaintiff's attorneys to frankly come in and make us, as you say, Griffin, SOL, standing for statute of limitations.
Absolutely.
And that's the big concern. And I know a lot of carriers and a lot of adjusters, definitely not my friends over at Secura, because they are excellent. But there's a lot of carriers out there who, to try to save some money, they just kind of sit back and I don't want to have to pay the law firm a contingency fee or hourly fee, whatever it is. And that ends up really messing with them in the end. So we say, come to terms, strategically select those states that you're going to intervene in, which should be the majority of them, to be honest. Figure other states. I mean, Pennsylvania, for example, there's some states where just New Jersey, you probably don't have to. But ultimately, there's still certain situations, even in those states where you don't have to, where counsel is necessary. I'll say all the time, probably 30-40% of the work comp claims I handle, I'm not just asserting a lien. I am the plaintiff's attorney, right? Either for one reason or another, the claimant isn't filing suit and they're not pursuing, so I'm pursuing independently for my client. Or even in certain states, we even enter into JPAs where we are jointly pursuing the claim and representing both when there's no conflict. So there's a lot of places where we fit in where needing and having counsel is relevant. Patti, do you have any comments on that?
I completely agree. You need to intervene on cases, and our rule of thumb usually is if we're not comfortable with the injured employee's attorney or familiar with them, we're going to absolutely retain counsel so that we're updated regarding mediation, things that are happening, because sometimes that falls through the cracks. And also you build that relationship, and many times you're the one that might end up driving that case a little bit more than if they're kind of in the back seat. So I completely agree. If it's a serious case, if it's a case that we don't have a comfort level, we're going to intervene every time and get counsel involved.
And that's another point I didn't even mention, as Patti said. Even in those states where you don't have to intervene, what if plaintiff's counsel doesn't know what they're doing, right? What if it's a 1-800, break your neck, I'll get you a check law firm, and they have some, brand new attorney handling it? Well, ultimately, that's where we can come in. So that's a good point. So through this presentation, next week, we're going to talk about a lot of really in-depth topics on investigating, why it's so important to investigate early, investigate often, and take those steps to make sure we're preserving all relevant evidence. Now, Patti, can you walk me through some reasons why you think investigation is so important?
It's huge, and everyone knows that. And my team is aware that's when the rubber hits the road, right at that initial stages when we have to get either experts involved. And that's because we need to get at that evidence, retain it, secure it. And mostly our first chance at that evidence, job sites, things like that change quickly. We'll get witnesses before they disappear and when their memories are fresh. And then really at the end, we're going, that time spent on an investigation in the beginning is going to pay off. So even though they may be working a long time on one file, it's going to pay off at the end because they need to get all that information now. They need to get in touch with the people and they need to get an expert out. So investigation is so important. And that's why, they'll just drop everything to work a file to work it through.
Absolutely. And from the legal side, we get the cases later in the game, right? After the investigation is typically done in most situations. We do have some clients that give us the cases from day one, but usually it's, 3 months, 6 months, even a year later, hopefully not 2 days before the SOL, because when we are SOL. But the big thing is we have more of a unique insight because we're seeing this kind of, having to recreate the wheel if everything isn't done perfectly. We get cases probably on a weekly basis, if not daily basis, where I take a look at it. It's slam dunk liability. It's beautiful. But something was missing on the front end, which is why it's so important. Now, Griffin, what are your thoughts? Do you have any insight from the legal counsel's perspective on why it's so important for carriers to immediately investigate?
Yeah, absolutely. I think one of the things that I fear the most is when a client comes to me with a month left on an SOL and says, here you go. We didn't do a lot of investigation, but we want to pursue this right now. What can you do for me? And I go, well, I could try my best. I'm not going to guarantee you anything. And really, if, a couple of times recently, clients have given me files like 2 weeks after the incident happened. And that is perfect. We're setting up inspections. We're discussing the claim with everybody involved. We have all the attorneys on notice. I'm able to send them constant notices of our lien, how much we paid. And ultimately, everyone knows who I am and what I'm doing. I'm not late to the game. That's really the most important thing. If I'm not late to the game, I can establish myself early and often.
And I'll also mention in the work comp context is there's certain states where we have to actually send notice to the claimant if we're going to pursue independently. Pretty common is a 60-day notice, where if we're 30 days out, I actually got this 3 days ago. I reviewed a case like this where 30 days out, we get the case. We thought claimant was going to file a suit. They haven't filed suit. What do we do? So, well, you didn't send if you said 62 days ago, if you told me, we could have sent the letter. Now we really can't. Only choice is to either consider joint prosecution, if possible, or try to find somebody willing to represent the claimant and file a suit, which happened to be, a week later, we found out that somebody actually was retained and they were going to file. So we were good, just overly proactive. But ultimately, that is a concern. But I'll digress. Now, Patti, it's also essential that claims adjusters, in my understanding, have expertise and training in how to retain experts, because that can be a huge thing in these comp claims, especially in the products liability context. In my experience, it's both an art and a science. Tell me a little bit how you keep your team up to speed in retaining experts.
Well, you really can't rely on that CV. What we have done in the past is we generally will reach out to counsel and get recommendations, but we also roundtable experts. And we take any opportunity we can to see that expert in person, whether they're at a conference, doing a presentation, to just get a feel as to how they would play out in front of a jury. And I've told my team over and over again, if you don't understand what the expert is telling you, the jury is not going to understand what your expert is telling you. So make sure that you have that understanding from them that they're going to speak at a juror's level, because that's ultimately who is going to maybe be deciding this case. But I completely agree. You need to keep a handle on that. Things can change. When possible, we will go on scene and just see how this expert plays with others. Does he get along? Is he aggressive? That kind of thing, just to get a feel for how that's playing out, so that we have someone that we're going to retain on our panel, or is it someone that we're going to consider? So it's one of those things where it's really always very fluid. People change, people retire, people join different firms, and things change. So it's a very fluid situation, but it's one that you really need to keep a handle on.
100%. I mean, being an expert and selecting experts is huge. And we'll talk in a few minutes more about the products cases. But one thing I will note now, since we're on this subject, is that it's really about, Patti made a really good point. Don't trust the CV. You can't just trust a resume for any of these folks or anybody for that, even attorneys and whoever it is. Pick up the phone, have a phone call. I use an example. I had a case, dock leveler collapse, case in California, crushes a guy, kills him, very sad. But what happened was our expert went out there, goes to the scene, looks at everything. And this was retained by my client, the expert. And what happened is the expert's beautiful, great resume. CV, went to Stanford, 35 years in the industry, PE, is a doctor, all the above. Checks all the boxes. Nobody called him on the phone to see if he was still sane. But what happened is he went out to the scene, shows up. I still remember his big white pickup truck, comes out with his big cowboy hat. Fine. I like cowboy hats too. It doesn't fit my head. But what happened was he comes out and he starts talking to OSHA, talks to everybody. And he starts saying how, hey, let me tell you, this is a gang-related hit. This is a murder by the cartel. And so, wait. Oh, this is the most obvious product defect you will see in your life. It was a dock leveler that had a safety bar that was the size of my pinky to hold up several tons of metal, and it collapsed, obviously. No question in my mind, this is a defect. Everyone agrees. The defendant would agree in most situations. Instead, gang-related hit, tell OSHA, I fire the guy at the scene, and I send him home in his big white pickup truck, and I reschedule and bring in a new expert. And ever since that situation, which was very early in my practice, I've remembered you can't trust the CV. Call your experts, interview them, ask them all the questions you can, especially in the work comp context. We have to be really, really careful that we avoid written reports, right? So no written reports. That's one thing I say in all my presentations. Anytime I can talk about product claims, never get a written report until you consult with counsel on that. All the time we'll get cases where maybe it's a written report. They think they're talking about the liability. They send you a report all in writing. There's no product defect here. Here you go. You're welcome. And little do we know, they had no idea that we were subro, right? So a lot of times we want to work closely with them, make sure, because the experts aren't attorneys. They don't always know what we need to be put in writing and what shouldn't be. So one thing I'll mention. All right. Next up. So this presentation is going to be primarily, as I said, next week about investigation, tips, tricks, things specific to the types of claims. As I said, we'll touch on auto general negligence, premises liability, and product liability. Now, I'd like to hit each of those today with you all. I'm handling the auto segment, for example. So we're going to talk about auto negligence cases. Pretty straightforward, right? A lot of you attending this podcast probably are from that sphere because most subrogation adjusters do deal with some auto. Now, in this situation, one thing that I always like to mention is that context and investigation is so key for auto claims, more than really anything else, because auto claims, the scene deteriorates really quickly. If there are tread marks, they're only going to be there for a few days. If there are witnesses, those witnesses are only going to be there then, right? If the police report doesn't document it, right, we need to try to figure that out. Sometimes business cards are exchanged. But even on the police report, I can tell you that if I take a witness statement, get that case a week after the loss, that witness is going to remember things that they're never going to remember 6 months later. Patti asked me what I have for lunch today.
What did you have for lunch today, Ashton?
I'm looking over here. I had a protein bar. It was delicious. Ask me what I had for lunch the day before that or even dinner last night. It's going to take me a lot longer, right? Memories change, things deteriorate like that. And that's where it's so huge, right? Getting reconstructionists early, making sure that we are documenting everything. Another thing is I think Patti's going to talk about premises liability in a few minutes. Everyone should have a cell phone. I'm holding it up right now to the screen, though this is audio. You can all see it in your minds. Everyone has a cell phone or a smartphone, basically, that can take photographs and pictures of anything. Take the pictures, take the photographs, send somebody to the scene. Interestingly, and well, sadly enough, one of my family members, totally fine, but they were in a car accident just a few weeks ago. Well, do you know what I did? I went right out to the scene that night. I started taking pictures, photographs of the cameras on buildings nearby. I'm in the middle. It's 10:30 at night. taking pictures. A guy comes out, starts yelling at me. What the heck are you doing on my property, taking pictures of my property? I'm like, hold up, family member was in an accident. I'm just trying to see if anyone has footage. He walks me in, downloads the footage to my phone. I have footage of the whole accident, right? Wow. If I waited 3 days, 4 days later, that probably would have been deleted. So that's where immediate, intense, and immediate, I'll repeat that again, investigation is so huge.
Absolutely.
Another thing I'll say is think like a plaintiff's attorney. And this is kind of hard for some people because in the auto liability end, it's really about creating narratives. It's about coming up with stories. A lot of accidents aren't just going to be, Joe Schmo rear-ended, Mikey. It's going to be, well, one saying that it's a green light, other it's a green light, who's responsible? Or the situations where, it is maybe 50-50, but we're coming up with arguments. A lot of times it could be the rear end collision claim. And I'm going to give during the seminar next week, we'll give a bunch of examples of this, but it's the rear end collision. A lot of subrogation adjusters have hard times with that, where they think, oh, it's a rear end. Obviously, the vehicle that rear ended the other car is responsible. Well, no, that's not always the case, right? What if that driver was slamming on the brakes for a stop sign? Or what if that driver, slammed on the brakes for anything else or swerved into the other lane or whatever it could be? We need to look into the facts, and there's no template procedures for auto claims. That's what I mean. Do either of you, Patti, Griffin, have any other insights on auto claims?
Nope, I completely agree. An instant investigation. Get as much information as you can. Capture those witness names.
Yeah, I'm with you on it.
Now, Patti, let's move over to product defects. I know that you do quite a bit with that. Product claims are really unique and also really difficult to grasp for a lot of new adjusters and attorneys. The procedure's 100% different from just an auto claim. The protocols, different experts, noticing up inspections, setting lab exams. Now, Patti, do you have any words of wisdom on the best practices to use in investigating these claims?
We roundtable those a lot. And to be perfectly honest, those are claims that you're going to generally get counsel involved, and you're probably going to get them involved right away because normally a manufacturer is not going to voluntarily pay you without at least a little bit of some sort of track of litigation. We really look at different theories. And as you may know, there's different components. So sometimes we have to dig deep as to who should all be put on notice, who should all be involved. So it's a situation where it is best to potentially either consult an attorney or just give it to the attorney, work with them on a theory. There's so many different avenues you can go. And sometimes you just need another set of eyes looking at it as to possibility of not just a defect or design, but we're running into lately cases where there's improper, warnings. So those are claims that it's best to just get as many people you can get together and bounce around some theories as to potential recovery.
Absolutely. And that's one place where, I agree that you should bring counsel in early on those cases. That would make my life a whole lot easier if more people followed that direction. But the other thing is, if let's say you're deciding to handle these things in-house, one of the biggest things is to ensure that we are adequately preserving the scene. That's right. The biggest part of this, because ultimately we get cases left, right, center, where we figured, well, we're just the work comp carrier. Plaintiff's attorney is going to do it. They'll take care of it. The next thing you know, all the time, we have another 1-800 break your neck, get a check attorney who's never handled a products case, coordinating a complex product scene inspection. Well, that's not going to work out well. Next thing you know, we get the case, had no part of it, but we find out they forgot to notice up everybody. They just did a scene inspection and then released the scene, got got the product, did a lab exam, didn't notice anyone. Now we're subject to spoliation claims. There are processes and procedures with any claim. And one of the biggest things I have to recommend, and I tell all my clients for products cases, is we're not just there when we do a scene inspection to retain the evidence, right? We're there to retain all evidence. It's every single item that could potentially have been at fault. Even if our expert tells us, I am within a reasonable degree of engineering certainty, which is the standard, able to say it was the toaster. Well, if there's a coffee maker right next to it, guess what we're going to do? We're going to take that coffee maker too, because the defendant could very well come back later and say it was the coffee maker. And if it's gone, we're going to have a really hard time saying that with certainty. So we're retaining all evidence. We're taking photographs. Matterport's a new big thing. Have you guys dealt with the Matterport cameras before?
No.
I've seen them.
Yeah,
Yep.
so Matterport, for large enough losses, we'll bring in Matterport cameras, which pretty much gives you a full visual 360 degree, now 3D visual of the space. So even when the scene's released, everything's basically still preserved. That's fascinating stuff. Drones are huge. There's a lot of things we can use to make sure that everything's being preserved as best as possible. But the number one best thing we can do on products claims, preserve the scene, notice everybody, not just the people you think are responsible, but the people that could be responsible for both the scene exam and the lab exam. Work with good experts. You're going to have a solid case. And of course, retain good attorneys. I think that's a given. Now, that's a lot of the main stuff on investigation. Patti, Griffin, do you have anything else you want to add before we move on to the different subject matter?
No, I think you called it right. I mean, even as a precaution, sometimes we'll secure evidence until the statute of limitations has expired, just in case it does get kicked around and someone we've had it retained, just for protection purposes.
And that's even on the smaller water supply line cases, because quite often we'll get claims where, oh yeah, it's a small, maybe $7,500 case. Is there anything we can do with it? My response is, well, where's the evidence? Oh, we got rid of it. We didn't ask the insured to keep it. So my short answer is no, we cannot. But for maybe one or two out of 1,000 claims where there's a recall or something else in place, you always need the evidence to be able to substantiate that case in a products claim. Couple other interesting type of cases we'll talk about in more depth during the presentation next week is going to be construction defect claims, right? There's going to be a whole different type of, that's a whole different animal. Construction defect, same with almost products. We want to take the time initially upfront to make sure we get all contracts, right? That's huge. Construction defect, products, ask the insured immediately, give me the purchase agreement. I need the deal between all subcontractors, construction contract. There's going to be 16 different subcontractors. I need all relevant contracts between all parties. Now, I was dealing with for years a lot of boom lift tip overs where the boom lift would go out, it would go too far on usually shaky ground, tip over, injure somebody. In those situations, we need to get the lease agreement for the actual boom lift. We need to know who owns that boom lift. We need the agreement between maybe the subcontractor operating and the GC or the owner. So really the investigation time, one thing to mention, time to get all contracts, because I can tell you, as an attorney, we're a little bit better at keeping records than other corporate setting. We're amazing at it. We have to be. At home, I'm not the best with keeping all my letters and all my stuff for tax purposes. I'm pretty good, but I think of the fact that, I'm probably in the top 1% of people for that. Think about the construction, the construction company who you come to them 2-3 years later and say, hey, can you hand me the lease agreement for that boom lift? Well, that's not going to, it's probably gone. So that's why we always say, get that soon, investigate early, investigate often, because it is a huge factor here. All right, next up, I want us to touch on just relatively briefly, all of the state-by-state variants when it comes to the comp context. There's so many different things that come into play. Investigative techniques, it's pretty broadly applicable, right? Whether you're in Illinois, Alabama, preserve the scene, take photographs, get statements. When it comes to actually how things apply, this is totally different. Moving on to these less broadly applicable things, let's talk about the first one, which would be, Griffin, can you tell me a little bit about the difference between how attorney's fees are applicable to allocation formulas when a settlement is made between the injured worker and the defendant, and those funds are then going to be distributed?
Oh boy. Yeah, that is a huge question that, again, I always go back to our chart. That's my starting spot is what's my state? What does the chart say? A lot of the times, I would say a lot of the states kind of do the attorney's fees and most likely costs come right off the top of any settlement or amount recovered. And then you kind of deal with the other liens and other portions after that. Now, some states cap that attorney's fees at a certain percentage. They don't want attorney's fees of 40% taking up a lot of the lien. Sometimes they cap them at 33. It kind of depends. Some states cap the amount of costs that attorneys can recover as well. For example, in Wisconsin, we have a pretty set formula on how to handle fees and everything, 102.29 is super easy to follow. A third of it goes to the attorney's fees and costs, and then a third of the balance goes to the plaintiff, and then the carrier gets reimbursed for the rest of it. If the carrier is fully reimbursed and there's still left over, that becomes a credit. So Wisconsin's pretty straightforward. You get what you get. You can sometimes argue, some stuff around it, but you're really not arguing anything. It's straightforward. Now, when you go to other states like Illinois, for example, Illinois has a lot of comparative negligence issues that you run into. Oh gosh, maybe we aren't recovering anything, and maybe we're actually liable up to a certain amount, and we're not going to get anything back on this, but we still have to have defense counsel within the third party action kind of making sure that we're not, taking on a larger chunk of stuff. So it really, states are wild in how they kind of go about the reimbursement.
Absolutely. And I know that just, the list I have here, I'm just running through it because we actually have this on our website. Arizona, no attorney's fees owed. So it's, that doesn't impact the allocation when you're figuring out what goes to claimant, what goes to carrier. Arkansas, carrier pays reasonable cost of collection and must intervene or risk losing entire lien. Otherwise, Wisconsin, obviously formulas filed. Tennessee and some other states, including Wisconsin as well in some regards, if there's active participation, then fees are apportioned also to subrogation counsel. So there are certain states where legitimately, it's not just we have to take a third off the top before we actually get our lien. We can actually recover our dollars back. So there's certain places where it's free, basically for all intents and purposes, free to retain counsel on the subro claim because you're going to have to pay it anyway to plaintiff's attorney or your own counsel. So that's an interesting one. And that varies very much state by state. Another important item of any allocation is going to be the applicability of the statutory credit. This is without a doubt the most important item that is overlooked by carriers left, right, and center. It's carriers deciding to waive that future credit. What that credit is basically it's the offset. It's the idea that under most allocation formulas, the plaintiff's attorney gets paid, the carrier gets something, then the rest goes to the claimant. But in those cases, the amount that goes to the claimant, and this is kind of broadly speaking, not universally applicable, then that serves, that amount is a credit, meaning that one, it can serve as a holiday in some states where the work comp carrier simply doesn't have to pay payments until you hit the amount of the credit. It can serve as a cushion. And the way that that's applied also varies state by state, but it's huge. I mean, the credit can often be worth way more than the subrogation claim. And one word of wisdom to all of you handling work comp claims out there is you cannot trust defense counsel to, unless you, really be careful trusting defense counsel to give you opinions on waiving the lien. Talk to subrogation counsel because I can't tell you how many cases, and I serve as national counsel for a ton of commercial auto carriers. And what they do is they bring me into several of these carriers on any lien waiver. They call Ashton to say, what does he think? And a lot of times defense attorneys, they don't have the ability to appropriately evaluate the value of that lien. What's the plaintiff's case worth? They're saying it's worth $10,000. Well, hey, if I think it's worth $150,000 and I know I'm going to recover that, then obviously waiving the lien for $20,000 isn't a great deal. So that's a huge factor. Now, Griffin, walk me through and let's discuss how this credit formula, how this is applied state by state and what kind of different variants you see.
Yeah. So you kind of mentioned, a general one where attorney's fees are recovered for, let's just say plaintiff, let's just say that the carrier is reimbursed and then claimant gets the rest of it. And the rest of the amount becomes kind of that credit, that future credit, that everything that they basically bill up to that credit amount, the carrier doesn't have to pay. And then everything beyond that, the carrier starts paying for again. Another one is, like I mentioned with Wisconsin, you got a third to the plaintiff's attorney, a third to the claimant, the rest to the carrier. And if the rest of the amount exceeds the carrier's lien, that portion becomes the credit. So it's kind of like an excess amount that becomes a credit for at least a little while. It depends on the lien. It's kind of the two main ones I would say that I see a lot.
Yeah, and this is one of the hardest thing for most people that come into work comp in general, especially on the subrogation end, is trying to figure this out, because most other issues and allocation perspectives are pretty universally applicable. But every state is so different on how allocation is going to be, allocated. I mean, you look at, we have a chart on this. I'm bringing us to our chart, pushing back there, and we have recovery allocation. What is it? The first one's Alabama. 1, carrier reimbursed less attorney's fee. 2, balance to the plaintiff. Then we just go to Arkansas. Cost and fees, 1/3 to worker, 2/3 to carrier, balance to plaintiff. Made whole applies. Let's just keep going down to show how different this can be. Florida, carrier gets lien, less pro rata fees, unless plaintiff shows Manfredo formula, which we do not want to get into Manfredo formula here.
No.
Idaho, carrier gets first dollar. The fact is every state is so different, and that's what we need to keep in mind. So knowing the right people to look to for these things are so, so, so important. Now that we've gone through that, now, Patti, do you have anything regarding the carrier side of that on when you're dealing with analyzing formulas or teaching your team how these things apply that you go into?
It's very important to address that. Like you mentioned, that can have a significant value depending if that work comp case has been worked up yet. But we need to consider that. We need to talk with the work comp rep handling the loss to find out what kind of exposure it has. But if it makes sense based on what our lien is and what our exposure is, it's something we really need to consider regarding potentially waiving, and also just making sure that that credit is communicated so that we do get that full value of that credit. And we have tools in place to make sure that that does happen. But they're really a big part of the work comp claim and very unique to work comp. So it is a training issue too, that you need to make sure that people are aware this is how that's going to work going forward.
And to make matters even more complex, I'm going to briefly mention extraterritorial subrogation. Not extraterrestrial subrogation, because insert any joke I can't think of now in aliens and subrogation. But extraterritorial subrogation. And that's the general idea that there are ways to use different state laws to our advantage in pursuing these cases. This is actually kind of where our firm's major work comp subrogation practice originated from, in that we started using really unique legal theories regarding conflict of law and choice of law to create recoveries on claims where initially either it was going to be something marginal or none was deemed to exist. And the general idea is that we're trying to find ways. Let's say incident occurred in one state, claimants from another state, benefits paid in another state, defendants from a different state, employers from another state. How do we argue in each state the best law to apply, and we can use that to substantiate and have a better recovery? Every state has different ways how they apply a conflicts analysis, and that could be a full presentation in and of itself. But the big thing is, we're looking at different factors, such as where was the claimant hired? Where will claimant file the claim? That's a first-party claim. Where was claimant injured? Where's employer located? Where's third party located? Where's lawsuit filed? Where's tortfeasor located? And we use that to determine all of these factors. From there, we determine, is there a conflict? Let's say, the incident occurred in Wisconsin, but the benefits are paid in Illinois, claimants from Illinois, all of the above. Well, first thing to look at is there a conflict of law? Suit's going to be filed in Wisconsin. Is there a conflict? Well, there are in some regards, right? Because it's a different allocation formula, a different way for this to come about. So the next thing we do there is we apply, we go to that state and we look to which state's conflict laws. What are the state's conflict laws? There's 4. There's the place of the wrong, lex loci delicti, it's called in Latin. 2, the Larson rule. The most significant context test is the next one. And lex fori, which is the law of the forum, right? So some states, only 12 states, the minority rule apply the place of the wrong. So that's where the loss occurred. That's the state's substantive laws that are going to apply. Larson rules is the enabling state. So some states say wherever the benefits are paid, basically. Most significant context, that's the majority rule. So those states will do an analysis looking to who has the most significant context, which state, right? And every state has different case law in place. So this is where even more complexity. So if we're doing the most significant context test, some states are going to have case law that say, well, where the claimant lives is more important than where the tortfeasor resides, or where the benefits are paid have a higher applicability in this equation that the courts do. So This gets really tough. That's where counsel should always come in. Consult with counsel whenever you think there's a chance to make those arguments, because there are going to be situations where you find that you have no right to recover based on the state's law in which the suit was filed, or vice versa. Maybe plaintiff's attorneys arguing that the law of the state where the claimant's from and benefits are paid, it should be the state's law that should apply to the substantive legal issues or allocation. So keep that in mind. I use that more as a teaser than as anything concrete. Learn about this, talk to counsel, and really that's, we could talk for another 5. What do you think? 5 hours, Patti, Griffin?
Absolutely. There's so much to it.
Right. Especially have 2 lawyers here. So, I mean, we could just keep Hey. All right. We're filibustering the podcast, just keep listening. Well, we'll cut it at that. I think that is perfect. I appreciate both your time today. I look forward to seeing you next week. Is there anything else either of you want to add before we cut off?
Like you said, we could talk for hours, but I think this is a great general overview of some of the things we'll be covering. We hope to see lots of you next week.
Yeah, I appreciate the time, and I'm really looking forward to it. So thank you.
All right. Patti, Griffin, an absolute pleasure. Always great talking to you. I'll see you next week. For all of you listening in, hopefully you can attend us at this upcoming podcast. Join us for this upcoming seminar in Chicago next week, CLM Work Comp Conference. That's all I got for you today. Again, Ashton Kirsch, your host with the Subrogation Support Network, signing off from beautiful Hartford, Wisconsin, and Griffin in Naples, Florida.
Yes, sir.
Have a good one, everybody.